respondent number 4, 5, and 6 has filed their affidavit in the first. That's what time for filing and planning.
The compensation, land compensation. Mr. P.J. Soike, Learned Counsel, appearing for the petitioner, submits that the respondents number
4, 5, and
4, 5, and 6 have filed an affidavit in the matter on date to the device.
yesterday I have received it.
So and so. Accordingly, he submits that he be granted 2 weeks' time to bring on record a rejoinder thereto on behalf of the petitioners. Full stop. Prayer is not objected to by the Learned Counsel for the respondents. Full stop. Accordingly, the registry to list these matters after 2 weeks on a date to be fixed by it.
Lordship, I beg to mention item number 25. That is, we have to take instructions and tell GST from the court government. We have no instructions.
There is admittedly 2 proceedings
Yeah, 2%.
on the same issue. Then
Under section 6(2).
6(2). How
Under
can this
CGST,
be?
Your Lordship.
How can this be maintainable then?
That is the question of law, yes, and we have already massive sent up.
Question of law, you should answer. Why are you asking them?
As per the provisions of law,
It
it can
cannot
be.
be. Huh?
It can be, but spite of, from my academic view, so rather to take instruction.
Mr. B.N. Goswami.
No, Lordship. My name is B.N. Gogoi. Lordship.
Gogoi, sorry.
Lordship
Mr.
is
B.N.
subject-
Gogoi, Learned Counsel, appearing, Learned Standing Counsel, GST, submits that he be granted 2 weeks' time to complete his instructions in the matter. Prayer is not objected to by the Learned Counsel for the petition. Accordingly, registry to list these matters again after 2 weeks. Any interim order?
Yes, Your Lordship.
Interim order passed earlier to continue till the next date of listing.
And deeply obliged.
Please, my lord.
Yes.
My lord, may I pray to mention item number 5? In this matter, on the last occasion, Lordship had directed the state to obtain certain instructions based on our rejoinders. That has not yet been received, and there is also some inconvenience on Mr. Chaudhary's part. Therefore, it may be deferred perhaps.
As prayed for by the Learned Counsel for the parties, registry to list these matters again after 2 weeks on a date to be fixed by.
I'm so
My lord,
pleased.
I beg to mention item 36, additional AG Mr. P.N. Goswami will appear for the government, my lord, and affidavit will be filed next week. So, my lord, may I pray that the matter
36.
my lord.
I'm appearing for petitioner lordship. They are saying,
The exact encroachment was directed to be ascertained by you
Yes.
because some government land
Yes.
was claimed. If they are on government land, evict them. If they are not in government land, don't evict them.
That can be also done.
lordship,
If that-
there is an interim order operating.
No. If you are not on government land, as you have stated in your rejoinder, that's the end of the matter. They will ascertain that position.
They are saying that they will file their affidavit lordship. And we will also file, we will have to file our reply also lordship.
They are not filing. I'm telling you that your case is 8884, something like that. Some government land you are being encroached.
They are saying that we are occupying.
Occupying. Your clear case is that I'm not occupying any government land.
They are.
That's the end of, they'll ascertain and they'll
They-
proceed.
That can be
Served
also
a
done.
notice, lordship, eviction notice that has been.
We'll
stated.
say that that eviction notice is subject to verification,
Yes,
field
that can be-
verification.
And, in this case, I'm led by Mr. Senior Counsel A.K. and
Chaudhary is there only. Mr. Chaudhary, the matter here is that land they use, you have categorically said.
It's a patta land.
Huh, you have
Let
categorically
them
said.
go to civil court, not this 18
That's what I'm saying. I'm saying that
Ah.
this notice, we will say, is subject to verification by the deputy commissioner, whether it's a patta land or a government land. If it is a government land,
It's a patta issue.
to you.
Yes. Patta issue, Jamabandi.
I have seen that. You have said that
Yes.
categorically in your rejoinder.
It's a patta land. I
They
don't
cannot.
know, Rule 18 or.
No, that will not come. No, they'll have to acquire that land.
Yes, if they want it. So let them file a
You
citizen.
just give me a clarification that on what basis are you saying? Because they have made categorical statements and you have not denied that.
It's there, Jamabandi is there.
Everybody thinks that.
Yes, my lord, the patta land is the adjoining land and the government land is
See, they have said, I think it is by
And
the
given
father.
that number, patta number.
It is by, you have given, they have given, well, let them file an affidavit.
Yes.
Mr. I. Bothako, Learned Counsel appearing for the state respondent submits that he be granted a 2 weeks time to file an affidavit in the matter. Full stop. Prayer is not objected to by Mr. K. N. Chaudhary, Learned Senior Counsel appearing for the petitioners. Full stop. Accordingly, registry to list these matters after 2 weeks on a date to be fixed by it. No further time. Because they should not be made to suffer if they are on a
my
patta
lord, may I pray for date?
date. What, Mr. When?
10th of June.
End of June. 3 weeks ko area. Hmm.
No, my lord. But the senior counsel said 10th of.
No, 3 weeks I'm saying. 10th will do. Okay, 2 weeks. After 2 weeks on 10/6/2025.
Another interim
Interim
order.
order passed earlier to continue until further orders.
Public.
May I present myself? I make a mention item number 26, my lord. In this case, my lord, we have filed additional reply, my lord, that is not taken record. That are very fixed on 4th, my lord.
What did you say there? The notice was not hanged.
So, my lord, in that, yes, our plea is that notice was hanged, but their plea, but we are denied that.
But the
Denied that.
Gaunpura signature is there.
But we are stating everything by in our affidavit in reply, my lord. That was additional reply that is not taken in the record. After
Your name?
AK Azad, my lord.
You are appearing for petitioner.
Petitioner, my lord.
Item number 26.
26, my lord.
Mr. A.K. Azad, learned counsel appearing for the petitioner submits that an additional affidavit in reply has been filed by the petitioner. However, the same has not been tagged with the records of the
4th,
case.
my lord.
Also, registry to trace and tag the records of the additional affidavit stated to have been filed by the petitioner. Full stop. And list the matter and list the same tag the same along with the records of the case and list the matter after 2 weeks on a date to be fixed by.
4th June, my lord. 4th of
2
June.
weeks. You make a mention. Yes.
Interim order is over.
Interim order passed earlier to continue till the next date of listing.
May it please your lordship, I beg to mention item number 7. Due to personal difficulty of my senior lordship, I kindly
17.
7.
7.
Due to personal difficulty of my senior lordship, may kindly be pleased.
You were supposed to file a reply, but you have not filed a reply.
My lord,
Why?
my lord will be, there are 2 affidavit in opposition. If
No,
lordship may
you have
grant,
been taking time for that only.
lordship may grant 3 weeks more time. There are 2
It's with
affidavit-
regard to that plot of land, mutation of a plot of land, 2
My lord,
kathas,
my-
2 bighas.
Yes. Lordship, 2 weeks time may be granted to file.
Because there is categorical statement that the land which was there, you had, I think, taken 4 bighas, 2 bighas were government land. On the prayer of the learned counsel for the petitioner, registry to list this matter again after 2 weeks to facilitate the petitioner to bring on record his rejoinder to the affidavits filed by the state respondents. No further time would be allowed to the petitioners to file affidavit in reply in the matter. Also, registry to list this matter again. List this matter immediately on completion of 2 weeks from today.
Much of it.
Yes, Mr. Dev.
Items 22 to 24, my lord. If Mr. S. Bhattakur is out of station today, my lord, it may kindly be listed in the next week or the week after, my lord.
Madam, who is appearing for the government here? You. There is a Supreme Court order. Still you are doing nothing. There is a Supreme Court direction for rehabilitation. You have done it part, but for them you are not doing it. If they are not entitled, you file an affidavit to that effect. We'll consider. But you can't hang them like this. 22, 23, 24, as prayed for by the learned counsel for the parties, registry to list these matters again on 14/5/2025. 14/6/2020. Oh, no. 12/6/2025.
Much obliged.
May I tell you? Lordship, with concern of other side, I beg to mention item number 31, Lordship. My senior Mr. B. Sinha is annual Lordship. Now he is bedridden. Matter may be adjourned for the.
A prayer is made on behalf of Mr. B. Sinha for an adjournment in the matter on the ground that he is indisposed. Prayer is not objected to by the learned. Have you informed the other side?
Yes.
Not objected to by the learned counsel for the respondent. Accordingly, registry to list these matters again. List this matter again after 3 weeks on a date to be fixed by.
Lordship, if possible, matter may be fixed on 28, Lordship.
Yeah, below. Project I have this file, my lord, to complete, my lord, the,
Okay.
the
The
office for
present, we have got it. But
But,
Mr. Akif,
But what happened was after filing of these implementing petitions, the petitioner has come to know that the incumbent has retired. So my lord, I may be allowed to.
you withdraw this file.
And would you know?
Mr. R.K. Agarwal submits that during the pendency of the present proceedings, the incumbent in the office of the Chief Engineer, Public Health Engineering Department was retired. Accordingly, he prays that he be permitted to withdraw the present interlocutory application with liberty to file a fresh one for impleading the present incumbent in the post of Chief Engineer, Public Health Engineering Department.
Oh, do you notice, my lord?
Also, after due notice to the present incumbent, prayer accepted, the interlocutory application stands dismissed on withdrawal with liberty as prayed.
My lord, it may be listed as 6, my lord.
You do it. We are not saying anything. You file it. It will come only thereafter.
The 12-month notice has to be given. to
You give it. What is there?
Oblige yours. Same, my lord. Second one.
Two also same. Same order. Belek Mahila.
Oblige yours.
Mr. Chaudhary,
Yes, my lord.
these matters, why we take up a interlocutory thing?
Ah,
We'll
both
go for
matters,
the
yes.
final hearing
Yes.
because you,
Yes,
have you
we
paid
will
that?
get an early disposal.
Have you paid that
Because-
25 lakhs?
Yes, yes. No, not only that, my lord. All that we are saying is bona fide of the action. Now, the person, the respondent number 5, who has been appointed as the receiver, he has faltered like anything. He has got no experience of tea. Now, the repayment schedule which he has given is 96 months, and our repayment schedule is 60 months. What is the bona fide? End of the day, you are repository of a public trust.
Trust only.
And I'll just show one document from where lordships can gather the impression about how things are going on.
Because see, either you or he, the
Yes.
garden should be
My
protected.
lord, I am the owner of
Owner
the
of the
garden.
garden.
And definitely I'll take care. Yes, there was some lapse. We are not disputing.
Where should I look for that
No,
document?
I'm showing one document, my lord. Before that, if your lordship would kindly have this, I think repayment schedule. Yes.
May I submit, Your Lordship? Lordship, we have filed a vacating application here. And that your lordship will be moved by a senior, Mr. T Das.
See, I was telling Mr. Chaudhary that.
That
So
matter-
why should we go into this intricacy? Because examining the interlocutory application, I'll have to go into the writ petition
matter,
also.
Yes,
We'll take up the whole writ petition for
yes.
disposal.
that is what we have also suggested last time.
Ah.
If your lordship wants to hear the entire matter,
We'll hear the entire matter.
yes. Then
When? Mr. Chaudhary,
My lord, next week, my lord.
can you have, what is that thing you wanted to show?
Yes, yes. FMD.
Because it will be a double exercise.
yes.
Yes.
Because I'll have to go into the merits of the writ. And you were heard also, I suppose? No. Yes, you were.
Yes, yes.
Yeah, you
While
were heard.
passing the order, everybody
Why
was
passing
heard.
the order?
It is not an expertise order. Now, for example, if your lordship takes Silkuri Tea Estate, certificate due is 3 crore 45 lakhs. Now, the receiver, what he will pay 2 rupee per kilo. So 21 lakh is the production, therefore 42 lakhs per year. If it is 42 lakhs, my lord, it will take 96 months.
And what
Whereas
is your?
our offer, my lord, we have already paid 25 lakhs.
Hmm.
1.6 crore, my lord, land acquisition compensation is due. Any moment we'll pay.
That has not been granted.
No,
till now.
not yet. In case delay of receipt or acquisition compensation, my lord, then our schedule is this. We'll pay at the rate of 2,67,000 per month, 60 installment, 5 years, it will be over. Whereas their schedule, it will take, my lord.
Mr. Chaudhary, just one clarification. This certificate due, is it freezed or there
No,
would
it's
be an
not
interest to that?
That's the extent of
That's not.
provident fund due, which we have
It's
to
11
pay to
crore
the
something.
provident fund authority
So there would be an interest component
Yes.
also subsequently coming in.
after the payment.
No, your
But-
lordship, interest is already accumulating. But as of today, on the filing of the IA, the due was 11 crores 25, both the gardens,
IA,
which is.
civil, 731/2025. Full stop. As agreed to by the learned counsel for the parties, comma, the About full stop. The learned counsel for the parties have submitted that this court would be pleased to take up the writ petition being WPC number 905/2025 for disposal at an early date. Full stop. In view of the above position, comma, the present interlocutory application is not considered and the registry is directed to list the writ petition being WPC number 905/2025 for final hearing at the admission stage.
30 next.
30? When Mr. Chaudhary, when Mr. Das?
30, Milord.
3.
No, first week.
30.
He wants it on first week. 3, third,
Fourth.
4/6/2025. Also, along with WPC number 906/2020.
The interim order.
Interim orders passed earlier to continue till the next date of listing. But there is no point in going into the interlocutory application. We'll go for the main.
It's okay, fine. And we late actually.
No, it's okay. We'll wait for that. Don't worry.
There is an option. There is an order passed by this court on 28/3. The direction was issued to my friend.
Yes, Mr. Pothakot, where is your affidavit?
My lord,
Records?
certain records, my lord. We are seeking just 2 more weeks to file it. We have received the necessary instruction.
This order was.
As far as my
28.
But the direction is that if you don't
Yes,
file, it's
personal
personal
appearance.
appearance.
Personal appearance.
just this one opportunity, my yesterday only the officers came to us, my lord. They are pursuing the Bakijai records in the ADC's office. And as far as detailed affidavit, my lord, I'll file it in 1 week.
Give me a date.
My lord, 6th of June.
6th.
Found
Mr.
it.
I. Bhattakur, heard Mr. B.D. Goswami, learned counsel for the petition. Also heard Mr. I. Bhattakur, learned standing counsel, Forest Department. Mr. I. Bhattakur submits, learned counsel for the Forest Department submits that the instructions for filing the affidavit, detailed affidavit has been received by him and the affidavit would invariably be filed on or before 6/6/2025. Also, he further submits that on the next date of listing, the relevant records shall also be produced before this court. Full stop. The prayer is not objected to by Mr. B.D. Goswami, learned counsel for the petitioner. Full stop. Accordingly, a last chance is granted to the Forest Department to file its affidavit in the matter and to produce the relevant records on the next date of listing. Full
This
stop.
record is rejected by this court. There-
Relevant records, we said. Full stop. Accordingly, registry to list this matter again on when? 11/6/2025. No further adjournment would be granted in the matter to the either side. Not like it last one, you might have to find a rejoinder.
I am pressing that the matter be disposed of today. There are interim.
It's
order-
all interim order passed. Last line interim order passed earlier to continue till the next date of this.
Much obliged.
Lordship, we are challenging the award passed by the Labour Court, wherein the respondent number 3 was reinstated with 50% back wages.
Mr. Dasgupta, their stand is that the standing order requires that you proceed on leave, you can remain absent after taking a consent. And that consent, and if not taken, within 10 days, if you don't rejoin, you are deemed to have abandoned yourself. There are,
This matter has been settled by the Supreme Court since long back.
but there are decisions with regard
Yes.
to the banks. I have come across 1 or 2 decisions about the banks wherein the standing order requires that if you remain absent for a particular period of time without intimation, you are deemed to have abandoned your service and the matter was upheld. But what I am finding it difficult here is the tribunal or the Labour Court has not recorded any finding to the effect that you had proceeded on You were absent after taking due consent.
No, even assuming everything, every allegation is correct.
Hmm.
Their allegation, 100% correct. Then also, my lord, if your lordship go through the definition of retrenchment, section 200,
ATDX. Industrial tribunal, sir.
industrial,
Disputes Act,
Dispute Act.
sorry.
this matter is settled by, there are a number of judgments.
Give me some view, because what I have come across is to the contrary.
No. Let me,
Right. Sir. If it is not there, I'll have to know that it is not there, so I can get it. Section?
section 200.
Hmm.
Defines retrenchment.
Hmm.
What is the retrenchment means the termination by the employer of the service of a workman for any reason whatsoever. That's very important. Otherwise than a punishment inflicted by way of disciplinary action, but does not include voluntary retirement, retirement of the workman on reaching the age of superannuation, if the contract of employment between the employer and the workman concerned contains a stipulation in that behalf. Termination of service of the workman as a result of non-renewal of the contract of employment between the employer and the workman concerned, and on its expiry of such contract being terminated under stipulation in that behalf, contained therein. Now let us come and see termination of service of a workman on the ground of continual ill health. If it does not come within these things, three A, B, and C, then it will be a retrenchment.
No.
Now, you should come.
Yes, yes, yes.
You should come. Should I read it?
No, I've got it.
No, any kind of termination, except the termination which is in consequence of a departmental proceeding, punishment, or voluntary retirement, or retirement on the attainment of age of superannuation, or continuous ill health, or there is a condition in this regard that you are for a contract of service on the expiry of that condition of service. There, other than any termination, any other termination, that will be retrenchment. Now, millards, there is a procedural safeguard in the industrial dispute itself.
Where?
Section 25F.
25?
F.
H.
F.
F.
Condition precedent to retrenchment of workmen. So, if it is a retrenchment, then you have to comply with these conditions. No workman employed in any industry who has been in continuous service for not less than 1 year under the employer shall be retrenched by the employer until A, workman has been given 1 month notice
But
in writing.
Mr. I've got it. Mr.
So-
Rasgupta.
Just a
If
minute,
these,
let
if
me, just, I will take 2 minutes time.
please,
Now, if these conditions are not fulfilled, these are mandatory provisions,
got it.
then the retrenchment is void ab
I
initio.
got it. I got
I
your
will
point.
give some judgment, milord.
I'll got your point. Just one clarification. When you are there, I can get that clarification. Now, if the rules, if the standing orders, they are binding both on the employer and the employee.
Yes.
If the standing order prescribes a certain mode, that if you are not there in service without, if you have left the service without permission, you are remaining absent without permission for a particular period of time, we will deem it to be abandonment of service. Now, in that situation, it is not retrenchment.
Yes,
cannot be requested.
abandonment of service is a request.
Just show me that.
Some judgment below right now I can, but I can give the site.
You,
Petitions.
no, you give me the copies because it will be difficult. Because that is the only point which I have to consider.
That is the
If
covered case,
abandonment
sir.
of service is retrenchment, then we will have to examine the matter in a different light.
The striking of a man, his name has been struck off on the road. That case is a railway case, my lord.
There is an SBI case.
Yes, your lordship, correct. SBI, State Bank of India versus N. Sundaramani. And there, Delhi Cloth General Mills versus Shambhunath Mukherjee. Hindustan Steel versus presiding officer Labor Code. More appropriate case is Robert R. D'Souza, the railway employee,
Okay.
Southern India railway employee. He was in leave. Without taking any leave, he went away. Then his name was struck off. Then he raised an industrial dispute. And that is the first case. Thereafter, Gammon India Limited, Glaxo Laboratories, a number of cases. If your lordship wants to hear me, then
We'll have to. That's your case, what I,
Essentially, lordship, that he is voluntarily abandoned, this is not a case of retrenchment.
it will not be a retrenchment.
Lordship.
Any authority to support,
I have very specific two judgments which are applicable, if I may.
please.
4 and 5. 4 and 5.
judgment will be yesterday. I have brought all those.
No, it's okay, Mr. Dasgupta. We are just trying to understand the issue.
That's all right.
So something new for me. So I'm trying to understand.
Not new to your lordship.
No, it's new for
Correctly,
me.
your lordship has gone to the point.
Lordship, first
At
I
one
refer
point of
to.
time, this was the view of the Supreme Court also.
Now
And
it has changed.
Then it, since 1982, it has gone away.
Lordship, may I refer specifically?
Anything more? This is the one.
Lordship, these two are otherwise that's squarely applied, very similar to our.
Where is the second one?
One is National Engineering.
National
Industries.
engineering, it's with me.
Lordship,
That I'm holding.
oh. There's one more such.
Same lines.
Lordship.
You are from this bar itself?
Uh,
You are from this bar?
yes, Lordship.
When?
Tomorrow,
Tomorrow?
oh, sorry,
I'm not
Monday,
coming.
Monday will not be here.
I'll not be here for 2 weeks. You can have it on a date convenient to you, whenever. you
Your
want.
lordship, I am not going out. That's why.
As agreed to by the Learned Council for the parties, comma, the matter stands adjourned today. Full stop. On the prayer of the Learned Council for the parties, the matter stands adjourned today. Full stop. As agreed to by the Learned Council for the parties, raised it to list these matters again on 12/6/2025.
Will I give the judgment, for judgment? Or
On that day, you can just give me the list. But there is a latest, I think,
Yes, sir,
with
that is
regard
the
to bank.
1993,
State Bank of India.
1993.
No,
PS.
thereafter. The bipartite, the latest the bipartite agreement before the last one, maybe around 2000, something like that.
Now this point was settled.
Settled. Fine. I was only under the impression that whether it would be a retrenchment at all.
At one point of time, it was.
He
a
would
law.
try to argue that it is not a retrenchment, it's an automatic termination in accordance with this understanding orders.
No, it is a
Two
case of-
decisions. No notice is required.
It is a case
Because
of.
Mr. Dasgupta, his projection would be that the lien is
Yeah,
no
loss
longer
of
there.
lien.
Loss of lien.
Loss of lien means abandonment of
Service.
service.
Your seat is gone.
Ah.
Your seat is gone.
Yes, it is gone. There is your name has been struck off. So.
Okay, fine.
It is come.
One more aspect is Lordship, section 12 of the Industrial Employment Standing Orders Act. So whatever has happened is through oral evidence. And section 12 very specifically
I'm not
says,
very satisfied with the manner the conclusions were drawn.
Lordship.
Because there is no specific conclusion either way that this is not permissible under the standing orders or it is in connivance with the standing orders. Only on the ground of notice not being given, the whole thing was
Last
interfered with,
paragraph-
whereas your contention was that no notice was called for because of the fact that he is no longer there. And your evidences also reveal that the competent authority to grant leave, because he had given an intimation
Yes,
to
but
two
not
persons,
but
not
to
to the competent person.
Not-
Whether Mr. Dasgupta will argue that that is enough. We'll have to examine that aspect
His
also.
contention is that notice was issued, but it was not served properly.
Notice
hanged
was
in
not
the-
issued
It was
and,
hanged in the notice board.
and yes, that is the termination one.
Ah.
But the second thing
No,
is that
notice, they have said is notice. Probably-
you have also intimated your immediate superior,
Hmm.
Mr. Goswami,
Yes, yes.
and one more person. We'll see, we'll examine. You make your arguments on that also.
All right,
That
it was-
whether we come to a conclusion that you had proceeded without leave.
No, no,
If
I
you can demonstrate also that, no, I had gone after intimation and due permission.
I will make my argument in a two-way,
Oh,
admitting they are all allegations.
allegations, so then you will have to
Then I have
satisfy me on that point.
Ah.
Fine.
Keep your views.
Yes, any instruction,
Lordship.
Hmm.
Lordship, he has left the job, Lordship.
any money?
No, see, he has retired from the petitioner firm, Lordship.
So monies which you are holding in trust, any money held in
No.
trust? Heard Mr. S.K. Agarwal, Learned Council for the petitioner. None appears for the respondents on call. For the ends of justice, registry to list these matters again on 4/6/2025.
Deep blue. pen.
So now may have to interfere with that. So we'll have to hear him.
Deep blue. pen. In the meantime, they have instructed me that the file has been closed by the respondent.
Then fine, you get Mr. Kayal to make that statement. Yes, where is Mr. Chaudhary?
I was trying to contact him, my lord.
We'll have it after some time.
My-
Because he is the one who is to now do this.
Yes, the last orders, man.
Lordship, I am newly engaged in this case, Lordship. We had to submit the affidavit in reply. The dates were allotted for this. But my colleague who were engaged in
I'm
this
sorry, it's
prior to
there
this-
for last around a year.
Yes,
More
yes.
than a year.
Now they have submitted one NOC to my client.
What is your right here to claim for restoration of your certificate of registration? That was cancelled sometime in appeal was sometime cancelled in 2007. The cancellation occasioned in 2003. You approached this court, withdrew the writ petition with the liberty to approach the appellate authority. Appellate authority has rejected it. The statutory provisions you have blatantly violated. Even after cancellation, you are continuing to collect money, deposits. Mr. Khan, Ms. Khan, we will have to.
Lordship, some misinformations are there. So after cancellation, we were not continuing the business. And the violations were in only two branches only. And those
Madam,
show
that
causes,
branches are your own establishment. It's one.
Lordship.
RBI considers it as one. RBI cannot take that cancellation of certificate of registration will be with regard to Guwahati branch, not Surat branch. It's one.
Lordship, there were some anomalies in the procedures also. We have replied to their so-called notices.
They have
and
gone
all.
through that. Nothing material has been brought on record.
Lordship,
Anyway.
give me one date to submit my affidavit in reply, Lordship.
Okay. MS JD
Count.
Learned Counsel for the petitioner submits that she be granted time till 5/6/2025 to
Lordship, 6 will be difficult because I'm going to Africa to attend some seminar. So maybe, Lordship, in the month of July,
when are you going?
on 6 only. So
On
last-
before 5/6/2025.
Last part of.
Madam, I have given this matter is pending for last 1 year.
Lordship,
for
I'm
your
very
affidavit.
deeply engaged, Lordship. I need
Can't
to
help it.
collect some documents.
I'm not with you. I'm with your petitioner. I'm saying this to your petitioner.
Yes, I understand, Lordship, but yes, the documents are also not there. I'm applying for the certified copies.
Can't
The
help it.
file
Why did you file
submitted-
the writ petition then?
Lordship, no, I'm newly engaged.
Madam, you are not, you are only a mouthpiece. It's a petitioner.
Yes, yes.
Why has he filed the writ petition then, if he does not have documents?
Documents are with the council, but council submitted.
Have you filed a complaint against the council?
Yes, yes, in bar council, they have filed some complaints also.
Where is that? Show me.
The bar council complaint paper is not with me. Now the NOCs are with me, Lordship. They have submitted NOCs. They have submitted NOCs some days back, and then I am
Is
engaged.
there
in
any
this
interim
case.
order operating?
I'm applying for certified copies of the.
As
report,
paid
Lordship.
for by Ms. J.D. Learned Counsel for the petitioner, registry to list this matter after 6 weeks. Nothing is there?
Nothing.
6 weeks on a date to be fixed by the registry.
My present.
Much obliged, Lordship.
Mr. P. Hazarika, Learned Counsel, appearing for the Reserve Bank of India is present.
I'm approved.
You take your time.
This is a Lordship.
Lordship,
Because last occasion, the court directed the respondent number 4 to file an affidavit matter. They have also paid for some time. That has not been filed.
Last 1 year, my lord, they are taking time and there is an interim order. Matter is pending since 2021 and the petitioner already filed a title suit to put the London court's future matter. I have copy of with this, my lord.
Mr. Counsel,
Yes, madam.
with pertaining to the same very land, there is a criminal case.
145 proceeding that Lordship is.
Why have you not brought that? There is orders passed there also. Why have you not disclosed that in the writ petition?
To our affidavit in reply. we have placed
That is affidavit in reply after the writ petition affidavit was filed by the private
Yes,
respondent.
Here we are agreed by the issuance of notice by the Silchar Development Council, madam.
And show me how you are entitled to 8884.
88884, madam.
Hmm.
That we have already stated in our. That
You say you are not,
No, madam.
we'll clarify.
It is not our tag, madam.
If they are not on 884, that is the end of the matter. But if they are on 884, you
Lordship, may
let
kindly,
the district administration take steps.
madam, paragraph 13 of our writ petition, madam, we have stated this categorically that this is not our land, it's a government land. Our house is, madam, it is our ancestral property, madam, which is in that number 88.
See, this is a property which
Yes.
was there of your husband.
Yes, it is.
Your husband is no longer in this world.
Yes, ma'am.
Page 10, paragraph.
Paragraph 13, madam, we have stated categorically, madam. It is not our land, madam.
Then why you are appearing for?
Malu, I'm for
Respondent of 4 and 5.
Huh?
Silchar development.
Why have you taken all these steps when she is not occupying that land?
Malu, there was a complaint received from the respondent side.
After the complaint was received, then we have initiated the process. After the.
In your affidavit, you have said some about some inquiry being made. Where is that?
Affidavit they have not.
My lord, I'm praying that can it be taken after some time? My senior SP Chaudhary wants to submit this contention, my lord. Just after some time.
Okay, fine. We'll accommodate you if it is required.
Yes, sir.
Well, affidavit will definitely clarify my lord this position by the respondent. authority.
Para 11, page 33. Internal page 7 of your affidavit.
Yes, my lord. There is a report and it's my also, sir.
Where is that report?
At page 42, my lord. Type copy 42 and submit copy is page 44. And tracemat's there.
What is the date of that report?
Report dated 14/9/21. On the physical inquiry, it is found that the second party instant case hopefully occupies the three-fourth part of the above homestead remaining 1/4 portion as buried and the nala. The expense showing that the speaker changes the post here. They are speaker and still attacked by the analysis in the list of both the contending parties and the in charge targeted police station. However, copy of the arrest of the post.
Mr. Counsel, where is your reply to para 11 of the affidavit file?
And my lord, I have also had original copy of the certificate copy. Please, my lord.
Got it. Now, where is his reply to your para 11?
My lord, is wrongly, the paragraph 9 is, my lord, is wrongly, it's a reply to paragraph
Help it.
12. Yes, my lord.
Can't help it. No comment.
Paragraph 12, my lord. It wrongly.
So
my lord,
if I,
it is 11.
paragraph,
My lord, paragraph 9, which in reply.
if I accept this, that's the end of the
That
matter.
have been the 11, my lord.
So that is
My lord,
upheld.
884 is not mine, and why the my lord, why should I claim it? I have never claimed. It is for, my lord, wrongly the has been.
Who is
done-
appearing for the deputy commissioner? Have you filed any affidavit here, Mr. Poku?
Respondent number 2 has filed one affidavit, my lord.
Therein it is, nothing is there. He says that it is up to the Silchar mood. But this is land. No, the inquiry.
In the counter also, they have said nothing. It's admitted that. If in fact my friend has got a certificate.
Of what?
Also, I'm gonna report my.
Well, fine, it's here only. 14/9, 31. Same thing.
My lord.
Okay, we'll ask them to take action in terms of this inquiry report 14/9/2021. We'll record your submission that you are not occupying any land.
Yes, my lord.
But if you're occupying land, they will evict you. They will
Okay.
demolish the structures.
But because my lord, paragraph
It's
13.
a public path, my lord. In fact, it's the over the cast.
Mr. Counsel, I'll only say that in terms of the inquiry report, they say that you have occupied 2/3 of the land in dark number 8884
Triple four.
and 1/4 is used as a graveyard or a nala. Now, you say that you are not occupying, you have not made any, you say you have not made any construction, you have not said you are not occupying. Very nicely written. I'll say that if it is, there is any construction made by you in 8884, the authorities, district authorities would be at liberty to demolish that.
Let me do, my lord. In the meantime, this notice, my lord, which has been issued on 8/10/2020.
That notice is gone now. Now it will be demolition direct order by this court.
The chief will just give me some time, my lord. The chief will, some time, my lord.
At 12 o'clock.
The title suit also pending. my
Oh, title suit is for what?
Yes, but for this particular land, my lord. Your lordship may kindly peruse the prayer of the plaintiff, and we have also submitted our written statement also. But the witness above direction, it can be disposed of. They are just lingering this. 2023 title suit filed, it petition.
Ravi, we double line,
They are lingering.
Ikini mari kini gusto. Tano kay gudi ako. Batang matili, medium ang matili. Baka to there.
And if anything say, my lord, they should, before the title suit. This title suit is also pending and filed by them, my lord. Now starting the road, my lord, public road, my lord.
Let him have his instructions.
Yes.
On the prayer of, we'll have it on Monday,
My lord.
Tuesday. On the prayer of Mr. This is item number?
Item number 11. my lord.
11.
Mr. M. H. Chaudhary, learned counsel for the petitioner, not objected to by the learned counsel for the respondents. Registry to matter stands adjourned today. Also, registry to list this matter again on 4/6/2025.
My lord,
No further adjournment would be granted in the
No
book.
matter, we have not sought any.
No, no, no.
go ahead.
You want your instructions?
That today, my lord, I have for instructions, I have sought.
You don't want an adjournment?
No, no.
You want an adjournment or don't want an adjournment?
Earlier, I have not sought any general matter.
Okay, cut it here. Argue.
My lord, no, today, my lord, only for the
Argue.
instructions, my lord. I have sought a general.
So for instructions, you don't, then what should I record?
Today only I have paid, my lord.
Any interim order operating here?
Yes, my lord.
Yes, my lord.
I'm vacating them.
At this stage, the interim order may be vacated.
I'm vacating them. What do you say?
Kindly consider.
Then,
That 8/10/21 has been kept in advance, my lord.
now that's what, I'll say that if it is not in 8884, then this will continue. If it is in 8884, this will have no effect. That much only.
That is why 4/6, my lord, and that they will appraise the honorable court, my lord, regarding that issue, my lord.
As prayed for by the learned counsel for the petitioner, Mr. M. H. Chaudhary, matter stands adjourned. Today, registry to list this matter again on 4/6/2024. No further adjournment would be granted in the matter.
But interim order continues, my lord.
Interim order passed earlier to continue till the next day.
Keep the effect.
Please, your lordship.
Hmm.
I'm appearing on behalf of D. Nath, my lord. I'm
Hmm.
appearing for PWD. We have received instruction, my lord. We need some time to file our affidavit.
Now, who is constructing this finally? It's the PWD. NHIDCL, then NHAI, then today PWD. So tomorrow you will not come and say some private matter is, we are not doing it.
File our,
No, fine. Ms. M. Das, learned standing counsel, PWD, submits that she be granted.
previous time.
Give me a date. Give me a date by when you will file. That the instructions in the matter has been received by her and the affidavit would be filed by the, on behalf of the respondents represented by her on or before
25th June.
25/6/2024. Full stop. Prayer is not objected to by the learned counsel for the petition. Full stop. Accordingly, registry to list these matters again on 28. No, 9.
Last week, my lord.
No. 3 weeks. 1, 2, 3. By 17/5, yeah, wait, yeah, 17/6. Huh? Affidavit by 17/6. Huh? Registry to list this matter again on 23/6/2025.
If the
Huh? You have Our Borough Learned Council represent, respondent number 2 is present.
I have received the record.
Huh.
Case model.
What is that? Whether it's a final award or
It's a final,
a final award?
and at one point of the, they tried to, they persuaded PWD to reassess, but that building itself has not been touched by the.
Why don't you file a short affidavit to that?
Yes, to that extent.
Oh.
And the road is complete, without even touching the building.
So if it is a final award, that is the end of the matter. How can we now come in?
Lordship, if that is on affidavit, then of course we'll have to challenge, because till today we don't know that. I mean, only from-
Once Mr. He's saying what more is required? He's a very responsible officer of
No,
this.
no, of course, I'm
Then-
not saying that.
He is saying that by way of some instruction.
Yes, no,
You give him that,
I have the report of the circle officer.
then you give him that, let him go and let him peruse that. We'll take it up after some time. If that is
It's in vernacular, the report.
on the prayer of the Learned Council, who is assisting you? Mr. B.K. Medi, Learned Council, appearing for the Revenue Department, no, for the state respondents,
Deputy Council.
the matter stands adjourned today to facilitate the state respondents to file their affidavit in the matter. So Mr. Medi submits that the affidavit would be filed on or before
Number 3.
on or before 13/6/2025, registry to list this matter again on 18/6/2025. Just bring that on record so that he can have. Ms. Bora, Learned Standing Council, NHAIDCL is present. That you have denied that. You have got no role.
Regarding whether Tala has power to review his own.
That if it is the final order, he cannot.
Cannot,
If it
but
is,
I have-
because the doubt was whether it's a draft order, award.
Yes.
Yes.
So if it is a final, that he cannot. I'm hope I'm correct.
Earlier they were passed.
Then fine, Blaji. Yes, Mr. Chaudhary.
Lordship. I'm sure, Lordship, I have not received any instruction. In the morning, I had a telephone chat. Lordship, they have asked for a short time, Lordship.
Short time means?
Lordship, 10 days or 2 weeks. Lordship.
Mr. B. Chaudhary, Learned Standing Council, BTC, submits that the instructions as sought for has not been received by him in the matter, and accordingly prays that the matter be taken up after 2 weeks to facilitate completion of instructions by him. Completion of instructions by him, full stop. Prayer is not objected to by the Learned Council for the petitioner. Accordingly, registry to list this matter again on 16/6/2025. Deep here. None appears for the petitioner on call. For the ends of justice, registry to list this matters again on 18/7/2025.
In this case, I have prepared the affidavit, sent it for vetting.
I know, I am told mother and I also, and as the document is as far back as 1990 for the government forces that I will have to come to de-reserve the land. On this, Tag 75 part 1. And
Yes.
Mr. Shama,
yes,
how large the area is of Dark 75?
very large, very big.
How
Mine
many
is only
private persons are there?
About mother, I could be
50%, 60%
No,
land is
no,
occupied
no,
by
more.
private persons?
more,
More.
more.
41 families,
No, no, no.
it says.
No, no, you say it's not de-reserved, it's a go reserve. And
No.
that go reserve is not de-reserved.
Did-
That
Huh?
affidavit is filed by us, my
Ah.
lord, the deputy
Your lordship,
commissioner.
I will
But,
come to,
The pretext that it's a VGR led, the policy, we cannot settle this now. Now there's revenue has instructions, my lord, regarding the premium, and it is already been re-reserved at the area. That instruction probably,
Then I have,
on that count, he has to file.
He has to, I'm going to.
So the deputy commissioner has got no idea,
Oh, it's
he has got no idea that the land is de-reserved. Then how he is, when he is saying that the petitioner is not entitled, how is the others who have been allotted land there entitled?
Initially, that process was on for long, my lord.
3 lakhs, he was, why was that process not taken to its?
That stand was not taken. in
You have also not taken any stand in that, in your affidavit. You were to take it forward.
that-
Government had granted.
But
3
the
lakhs.
reservation is to be made on behalf of the government.
Now, if it is de-reserve, what about the other persons who are occupying land there? Private persons. I understand the public buildings. But there,
school.
you evict all, we will dismiss his writ petition. Evict all. If it is go reserve, it is go reserve for all.
But their premium has been fixed at 3 lakhs at that point of time, my lord.
That
Probably
we are not concerned.
it has to be given to them on.
Now, once the government had directed, why have you not taken the matter forward?
No, it is already sent to the revenue department for de-reserving, my lord, particular.
So, how have you allotted the other person's land?
That reply, that.
You
that
get
is-
it by 2 o'clock.
that
Get
is
it by 2 o'clock.
Monday by. I'll try it.
But if the others who are there, same patta, now that has been same DAG number that has been now segregated, they have been allowed allotment, why not the petitioner?
Private persons are concerned. We are stating in the affidavit that all.
You mean to say that your affidavit says that there is no private person there?
That stand is not clear, my lord.
Then
Their reply.
nothing is
on
clear.
reply, they have
Nothing,
not-
they have also said only about the government institutions.
But some.
Arunachal Bhavan, CAT, we understand that.
Ramkrishna Mission, City Madrasa School,
That all are public institutions.
Private,
that
all
land is
private.
allocated. That is.
Don't file such affidavits. Your DC will be in trouble.
my lord, will kindly go to page number 72.
I've seen it, Mr. Mr. Vachaji, when are you filing?
Within 1 week.
No, give me a date.
1 week will be.
Back in 94, government asked to re-reserve it, and now.
Can it be on
30.
4th?
Mr. A.
52 years.
Vachaji, Learned Standing Council, Revenue Department submits that the affidavit on behalf of the respondents represented by him would be filed on or before 4/6/2025. Also, registry to list this matters again on 16/6/2025. In the meanwhile, the petitioner is at liberty to file his rejoinder to the affidavit filed by the Revenue Department, if so advised. Also, no further adjournment will be granted to the Revenue Department authorities to file their affidavit in the matter. Also, in the event the affidavit is not so filed before the next date of listing, is not brought on record as directed herein above, on the next date of listing, the secretary to the Government of Assam Revenue Department shall personally remain present before this court to assist this court in disposal of the petition.
But they have already filed one affidavit.
Who?
They have filed,
Revenue Department.
yes.
DC has filed, Revenue has not filed. The last line to cut it.
Your lordship. Yesterday we have filed our affidavit.
You have filed the affidavit on behalf of the government.
Yes.
When did you make
yesterday.
your first application? Application for H form inclusion.
Senior next, kindly pass over on that.
You don't attend your seniors' chambers. You can't read English. Why have you not gone through the brief? Why? Senior does, who is your senior?
Yes, sir.
Huh?
Yes, sir.
He does not allow you to touch the briefs.
Allow you?
Then what were you doing yesterday in the chamber? How long have you been in practice?
I'm still sorry.
No, how long have you been in practice?
It's 3 years.
3 years. Still you have not gone through the brief.
Why it is not with me?
At 2 o'clock, I'm coming back. Go and read the brief. Come back. Tell me, on the date he applied, that was within that COVID period. He had a valid registration, fitness certificate with him.
Oh, Lordship. We don't have the valid, all the documents which is required to convert.
Madam, I got it. That during that period when he applied, all the documents got extended from 2020 till 36/2021.
Yes, for the vehicle, but not for the H form. H form is different, my lord.
Hare, H form, why he is not giving granted H form? He is not
Because
granted H form. Getting it? Clarify if I am wrong. He submitted an application for being granted H form.
Sir,
You have not given him that thing because his fitness certificate was not up to date.
not up to date.
Now that fitness certificate from 2020, in terms of the Government of India in direction, is extended till 21 June 36/2021. So the fitness certificate he had, that is valid. How could you have rejected his application?
Because we are following the notification issued by the central government, Lordship.
You are following?
Yes.
Central government notification
Yes.
says everything stands, validity stands extended till 36/2021. He submits his application in between them.
Lordship, grant me 1 week time. I will get the specific instruction
What?
regarding the data
Your
application.
affidavit is on record, but you don't
Yes,
touch
but the
this one.
date is not the page 51, Lordship. May kindly have a look my affidavit. Running page 51, my lord. Question, it may be the reply, Lordship, they have filed an RT application, the reply is there. It may be stated that your age form in respect of the regulation successors could not
So-
be entered.
Serial number 2, vehicle fitness certificate.
Yes,
His vehicle fitness certificate may have expired in the meantime. But all documents pertaining to a vehicle from, I think, how much? 1/2/2020 to 36/2021 is valid. So how could you have rejected his application? Have you got it subsequently? Have you got the registration subsequently?
Yes.
Huh? Then what is left here? Get your senior
Lordship.
after some time.
Lordship,
Let him get his senior.
Lordship, the central government.
Next time, Mr. Counsel, whenever you come, the facts must flow. Let his senior come.
Wait, please, your Lordship. Lordship, I'm appealing for item number 21.
Same issue in both the cases.
As per last order.
What have you done? Why? How can you retender the whole thing? Where is your power? Yes, Mr. Gupta, Mr. Soma, where is your power? What is the fault of the petitioners?
Contract 21.1 of the contract agreement.
Okay, come to 21 point. Ms. Soma, take your seat. 21, okay. Now you have the power to terminate the contract by giving him a month's notice.
We
Right?
first we ask him.
That
whether
cannot
he-
be on the basis of your sweet will. There has to be some violation on his part of the contract agreement.
Lordship,
So
it's-
that violation can only be relatable to 17, clause 17.
Lordship, clause 21.1,
Mm.
Lordship. Railway shall have the right to terminate the contract or agreement for any reason whatsoever after serving 1 month's notice to the leaseholder.
Mm.
However, Railway shall reserve the right to terminate the contract as a punitive measure without any notice at any time in case of breach of agreement or serious violation of any of the stipulation of policy of Railways.
Fine, for any reason. So there has to be a reason. What is that reason?
Reason, Lordship, we have to facing difficulty because of that in Guwahati, we have to detach that.
You
and
get
yes.
your VPU till Guwahati.
Yeah,
So the agreement is till Guwahati, you will have to detach that. Now that Guwahati is an intermediate station, so you have 15 minutes stop.
Yes.
You cannot detach, take that vehicle
Yes.
away, it's problem for you. Come to 17. Clause 17. Page 47 of the first case.
Extension of train or increase in frequency of train.
Hmm.
In case a train in which parcel space has been leased out is extended beyond its initial originating station or beyond its initial destination station, then the leaseholder will be permitted to continue his lease between the pair of station mentioned in his contract.
So, A to B is the initial contract. Now, A has been extended to A1 or B has been extended to B1. But the petitioner shall continue from A to B only. That is clause 1. Come to clause 2 now.
However, if the leaseholder wants to extend his lease to cover the newly extended portion, also then the same may be extended and lump sum lease freight charges will be increased on pro rata basis as per his existing lease charges for the extra distance.
So 17.2 is if he wants, he approaches you, you can grant it to him with proportionate increase of pro rata basis. Now come to 3.
However, in case the existing leaseholder is not prepared to extend his lease beyond the starting and terminating station for which the contract has been executed from division or zonal railway will be at liberty at fresh tender for the newly extended portion.
So your option now is you can float an extended tender from Guwahati to Silchar for one train and from Guwahati to Agartala for the other train. That's it. How can you terminate?
Lordship, we have asked him whether he is ready to.
If he is not ready, you will have to fall back on 17.3 only.
So
You extend, you contract out that period, that portion separately. This is your contract. How can you go beyond this?
subsequently, their stand is that they are ready to continue till the new extended portion. And the tender notice was also issued, but there was no party had filed their tender. So it is still that option is there. Lordship.
So she is, they are operating till Tripura and Silchar now.
No, I think we have.
You are agreeable to
That
operate?
is still Lordship.
No, they are not agreeable. How can you issue a fresh tender notice here? Yes, Mr. Gupta, what is your take? Don't fall back on 21. 21 is nothing. That has to be supported by something before 21. And that something is only in 17.
Because as a policy decision, it is difficult to operate only for that portion.
That you should have. This is not something, Mr. Gupta, you are doing for the first time. If your organization cannot visualize this situation, why should the petitioner be penalized? You should have visualized that situation here only. You have not visualized that situation. It's your fault. So don't disturb her till the period. 26.
No, Lordship, 27.
27. One is 26. Yours is 27. Other one is 26. So, close it.
But the contract clause, if I may read clause 21.1, that.
Okay, 21.1, just show me the reason. What is the reason? That's all.
The reason, is given in the termination letter itself.
Okay, that cannot be a reason because that is not supported by 17. He is not bound to accept that.
Because that clause says, for any reason whatsoever.
Be that as it may, it cannot be that you will also violate her right which is flowing from 17.
It's a determinable contract,
It is not. It is not. Because the contract itself envisages that if he does not accept, you will retender from the existing to the extended. 17.3.
But in case, that is not feasible to the railways.
Where have you shown that it's not
Railways have
feasible?
right to terminate.
I'm sorry.
If it is not feasible.
You have not even filed an affidavit here.
Okay, I have filed one.
Where in the second one? Okay.
Page, in WPC 11117 of.
Okay.
Page, 82, paragraph 10, we have given the reasons.
Eighty-two?
Page 82, my lord, paragraph 10. That with regard to the amendments made in paragraph 3.
82, paragraph 10.
Because initially, my lord,
I'm
this-
sorry, this is contrary to 17.2.
the train.
You
was-
cannot force her. It's her voluntary acceptance of that. If she accepts, if he accepts, fine, but you can't force her. What you're trying to project here is, you asked her to do it, she's not doing it, so we are terminating.
That right is also there, my lord, in my
Where?
humble submission.
Where, come to
in clause
17.
21.1,
I'm sorry, I'm sorry.
operational exigency is there.
It's, that is the reason.
It's not that railway is totally
Madam,
unreasonable.
that has to be incorporated in 17.3. Otherwise, that violation of 17.3 is there. And rightly interim order was passed quoting that there was no misconduct on the part of the.
But the railways, my lord, stand is that for that extra portion, my lord, that will cause them difficulties, my lord, for that.
So, Mr. Gupta, why did you incorporate 17.3 then?
Time lordship,
That time
subsequently,
stopped, you are stopped.
If my lord will take that paragraph, my lord, this train was extended to Agartala, my lord, subsequently.
I
That
got
is-
it.
Yes.
That is envisaged in clause 17 of the agreement.
And we were. ready
Anything
to-
more?
So that is my humble submission. Two judgments I am relying, my lord.
What, on what point?
On this determinable contract. my lord,
Forget
because
determinable contract. It cannot be in air.
condition is that only, my lord, because.
Yes, madam. What do you have to say?
Relying upon the clause 17 lordship, 17.1 and 3 lordship, these two clauses safeguards the right of the petitioner lordship. They can extend that portion lordship by floating a fresh tender. I have no objection on that, but for my tenure lordship, I have the privilege to enjoy that period lordship.
This is Mr. Gupta only to show that something, but what about 17? How do you get over 17? 21 does not have an overriding effect. It has to flow from some violation of some contract provision.
No, the language is any reason whatsoever.
Any reason whatsoever would not mean that you can do it as per your wish. Even invoking your para 10 says, because she has not accepted that, we are terminating. It cannot
The
be.
meaning of determinable contract, my lord, that gives
I'm
the
sorry.
scope.
We need not even go
They
into
can
that.
ask for compensation,
Why?
but
Why?
not, well, because
The power is given to you in 17.3. If she does not do it, you float a tender for that portion.
yes, my lord, but again, we have expressed our difficulty, why we could not.
That
float.
you cannot. That you ought to have done it here.
Because for that small.
Because you are,
portion,
the contract is binding on her. It's also binding on you.
No, technically, no, it is not feasible for that small portion to float. That's why we requested.
That you will have to
And
suffer.
then in
That you
case
will have to
that is
suffer.
not acceptable to them, my lord, then we exercise the power under
I'm sorry.
21.1.
I'm sorry. Because there is nothing against the petitioner for operation in the original route. Nothing.
Yes, extended, we also requested we will pay the pro rata charges. If you operate.
That is why I'm saying
But
that
they
is the
say
option is
no.
hers or his. If they don't accept, the only option left to you is on that count to retender that portion.
Public interest also should also be.
There is no
vague,
public
my lord,
interest here.
Because
But
it's not
in a
that railway is
contract,
doing it arbitrarily.
equity and all those things stay at a distance.
Difficulties of both the parties has to be, that is why we exercise power under 21.1.
Mr. Gupta, what made you to formulate your clause 17 in this manner? Anything more?
That is.
Heard Ms. M. Sharma, learned counsel for the petitioner, also heard Mr. Ms. Sharma, you are appearing for
Item number 21.
Ms. B. Sharma.
No, Lordship, for petitioner, I am for item number 20.
Okay, none appears for the petitioner in WPC number 1020024. So Ms. B. Sharma, Learned Counsel for the respondents is present and has made a submissions. So Ms. M. Sharma, Learned Counsel appearing for the petitioner in WPC number 1117-2024 has made her submissions, and I've also heard Mr. H. Gupta, Learned Counsel representing the respondents in WPC number 1117-24. Hearing completed, registry to list this matters again on 12/6/2025 for delivery of orders.
Lordship, interim order.
Interim order to continue till the passing of the final orders in the matter.
Okay.
I'm sorry, can't do it. You can't do it. Oh. Where is that order of Justice Manish Chaudhary, M. Chaudhary? I think it has been settled.
Lordship, that was Lordship regarding broader issue, Lordship.
A broader issue, the smaller issue gets covered. Where is that order? When was the order passed? Recently?
Yes, Lord.
You have that copy, the number, Ms. Barua.
Number is there, Lordship. WPC, repetition civil number 5346/2024.
53?
5346/2024.
Date, order date?
Order dated.
Just show me that order.
24/4/2025. This is a Lordship, voluminous order, Lordship, 195.
195 pages order, Lordship. 195 pages order.
You have it?
Partially.
Ms. Barua, you say that this case would be covered by the order.
Yep, the Lordship, actually 3 writ petitions were filed together simultaneously. Only this writ petition was not decided.
included.
The rest, other 2 were decided. I cannot remember the writ petition numbers, Your Lordship. I think this will cover this case.
Lordship, in the similar issue, Lordship, 3 writ petitions are Lordship filed, Lordship. And 1 writ petition civil number 53/2025. That was, Lordship, already passed some order, Lordship. Certain observations was made, Lordship. That defect was made in the Lordship voter list. Because Lordship, from the same
Item number
members-
28, 29 is same. Right?
29. Lordship,
28, 29 is same.
Your Lordship, I'm appearing for 28. 28 has been marked actually.
Only 28 I am appearing.
28.
So, Madam Kashyap, you get me a copy of that order next day. Or you can give her the number, she will take it out. We'll have it along with that order. I'll have
Obliged.
the order taken out.
Yes, obliged.
As agreed to by the Learned Counsel for the parties, a registry to list this matters again on when, Ms. Barua?
Now, Your Lordship, next week, any day next week,
Okay.
except for 3rd.
Let it be on 8.
Yes, Your Lordship. Yes,
6.
sorry.
No, sorry.
8 is Sunday.
Sorry,
Your-
9, 10, 6.
Absolutely.
No. It would be 3.
The 3rd, I'm not available, Your Lordship.
Or next week, we can have it on 29th also.
Yes,
29,
Your
5,
Lordship.
20.
Yes, Your Lordship.
Obliged.
Very well, Lordship. Yeah.
You give that number. At a copy of like 195 library could live library.
Much obliged, Your Lordship.
Same thing.
Same.
It will be 29th.
30 same.
Same.
Yes.
Same order. Beleg order, no? Separate manage. When was the death?
In the year of 1991.
Does the subsequent notification of 2004 have a retrospective effect? Simple. That much only you tell me, I'm passing others. Then why only 2024? It was again amended in 2014. 2014 it was amended. So why don't you take that benefit? And what about the delay from 91 to 2005? How have you explained that?
Lordship, enhancement amount in the year of 2014 Lordship.
Hmm.
But prior to 2014 Lordship, only 1 lakh rupees is granted to us.
Tell me how you are entitled.
I will
The circular holding the field, when you had that unfortunate incident at occasion, you were compensated. Now, subsequently, what comes? How can you be also claiming that? In 25, another may come, you will claim that also. So tell me from 91, what were you doing?
91 to Lordship 2014. Amendment has been, notification has been.
Show me
received
how
by
you are
Lord
entitled to the
2014.
2004 notification. Show me. Yes, Mr. Sharma, how is he entitled?
Lordship, we have received a set of instruction by law. Where is the? It's a.
Yes, Mr. Sharma. How? Just answer that I'm ready to pass the order. Why 3 lakhs? I'll give you more. But tell me how I can give you. What is your instruction? He's eligible.
The interdepartmental inspection, my lord, regarding one top list that victim, my lord.
One top?
One top the list of victims, my lord, that Goro movement. He is asking for especially the terrorist.
You're also on a different plane. Your instructions are on a different plane. The death occasioned in 1991.
My lord.
He was given the amount of compensation as was prevailing at that point of time. In
Rest-
2004, you increased it.
Yes, division bench.
In 2025, he is coming before this court saying that give me that increased amount. Whether he is entitled. Only on that point. I think I have passed an order, not entitled. I don't know what happened thereafter.
Your Lordship, some similar situated person has approached before the Honorable Division Bench after observing the Honorable Division Bench.
My Lord Justice Mishra's order.
Yes, Lordship, Honorable Honorable Chief Justice as well as the PP Kotoki.
Where is that order?
Lordship, Annexure 5, page number
That
30,
is
Lord.
Onishar Basumatari case, my lord, to my knowledge. WPC 3355/2007.
Come to para 10. You're relying on this. You're relying on this.
Yes, sir.
Come to para 10. Okay, Ms. Burman, you have your instructions.
My lord.
On the prayer of Ms. M. Burman, Learned Counsel appearing for the state respondents. The matter stands adjourned today to facilitate her to complete her instructions. Full stop. Registry to list those matters again after 3 weeks on a date to be fixed by same in item number 33.
Your Lordship.
Demarcation.
We've been awaiting a demarcation since 2018, my lord.
We have filed our affidavit, Lord.
Hmm.
That is filed on 21/5.
It's on record.
Lords.
Page 178 for a moment if the lordship takes up. The demarcation was in fact attempted, my lord. It was
But your co-patadas had they raised some.
That is the
some objection and there was the boundary mark.
But
was-
I think in your repetition, you have said that the director of land records
They've
had
done
made.
They've done that.
So
Now I believe there's no impediment. Only fear is the Lat Mandal was threatened on the ground. So therefore, we are seeking some assistance from the police. That's all.
Lordship, but even then, in case of a demarcation also, we cannot hand over the position.
No,
That power is not with us.
who is asking you to do that?
Lordship, regarding that demarcation, because of that objections of the co-patterners, we are unable to, Lordship.
So in
Hearing
a
should-
situation wherein the co-pattadas have
In that
objected,
case, Lordship,
what would be the option available to either the authorities or to you?
Well, look, I believe so far as demarcation is concerned, I'm not insisting them to evict encroachers.
That
We
is
just
different.
want the boundary marks to be placed. Now, this is a statutory duty of the revenue authorities, even
To do
under
it.
the land records manual.
Mhm.
Now, they have themselves said that the field heap or the stone prism has been displaced out. Now, the survey has been done. Now, even if there is no prayer for demarcation, it is their duty to place the boundary mark.
Boundary walls.
Boundary marks since, so therefore, all I'm praying now, demarcation, whatever objections are raised, they're not on record. It's just that the Mondal says when I go to visit, I'm obstructed. So
So
therefore,
for that, you will have to have a
in
protection.
that case, Lordship, a hearing should take place before the circle officer. He should call Lordship. So if that direction is given, by keeping this matter pending,
No, we are not doing that. We are directing the deputy commissioner here
Lordship.
to take necessary action to see to that the demarcation process is taken forward and resolve the issue and then come back to us.
Lordship,
All parties will cooperate.
Lordship.
Full stop. Likho. Heard, Mr.
But,
P.D. Dekka.
maybe one problem is there with private party. Private party is private party is private party. Huh? Private party, no problem. No, co-partner party to have. That's.
Is not made parties here. Anyway, you take
they
your
issue
call.
notice.
Lordship,
Uh,
Lordship.
Heard Mr. B.D. Dekka, learned counsel for the petition. Also heard Mr. H. Sharma, learned counsel appearing for the
Respondent number
government
2, 3,
advocate appearing for the respondent number 3,
2, 3, 4, 5 and 6.
2, 3, 4, 5 and 6 and Mr. A. Bhachaji, learned standing counsel, revenue and disaster management department. Also, the deputy commission, the circle officer Rania has filed an affidavit in the matter and therein had taken a plea that the demarcation as prayed for by the petitioner was not possible to be taken forward in view of the objections raised by the co-partadas during the demarcation process, and accordingly, the same continues to remain in a stalemate. So, in view of the above, and as agreed to by the learned counsel for the parties, the deputy commissioner, Kamrup Rural is directed to examine the matter and take all requisite steps for carrying out the process of demarcation as prayed for by the petitioner. Also, for the said purpose, if so required, the deputy commissioner shall afford an opportunity of hearing to the petitioner and all other stakeholders of the land in question and thereafter take the matter forward in accordance with law. Also, a report with regard to the manner in which the same has been proceeded with by the deputy commissioner shall be placed before this court on the next date of this thing. Also, registry to list this matters again after 6 weeks.
Lordship,
6
after a
weeks.
vacation, Lordship.
6 weeks, list this matters again after 6 weeks on 18/7/2025, on which date Mr. Sharma shall place before this court the report of the deputy commissioner. I think now it will be resolved.
Lordship.
Deep here.
May I please your lordship? Lordship, on the last occasion, that is on 4/4/25, the respondents were directed to file.
Yes, Mr. Sharma.
Lordship, we have received that instructions whereby it is stated that the joint survey is fixed on 28th of May. This may be kept as a part of the.
No. Your word is enough. Mr. Sharma submits that the respondent authorities have initiated a process for carrying out a joint survey of the land in question to ascertain as to whether a patta land of the petitioner has been occupied by the respondent authorities and the same is fixed on 28/5/2025. So, Mr. Sharma submits that the matter be taken up after 28/5/2025 to enable him to place on record the report of the report prepared after the joint survey is so carried out. Full stop. Prayer is not objected to by the learned counsel for the petitioner. Full stop. Accordingly, registry to list this matters again on 11th
11th of June.
June
Lordship.
11/6/2025, on which date Mr. Sharma shall apprise this court about the outcome of the joint verification process now carried out.
Right.
It will affect TDO. Mr. Sharma,
Lordship.
you have rejected the NOC. Why?
In item 37.
37, it's a series.
37 to
37 to
44.
44. Yes. What is the reason?
Various cases, reasons are different.
Will be different, but there will be some reasons.
Yes,
Why don't you bring that on record?
my lord, for lordship's perusal, similar set of same count, my lord. Ordinance has already.
Have you seen this order? Go through it.
In this order, my lord, only election order was directed to be communicated.
Naturally.
Another notification will come.
No. It is not that. The rejection has been interfered with, and they have been now directed to consider the matter afresh and pass a reasoned order and speaking order within a period of 45 days from the date of submission of a copy of this order. I think that will satisfy your thing.
The X says, my lord, there is no scope for rejections. It says, my lord,
Then we'll hear it. You file your affidavit. Ms. M. Burma, learned counsel appearing for the petitioner, submits that the present writ petition is covered. Writ petition is covered by the order, date, judgment and order dated 3/4/2025 passed by the coordinate bench of this court in WPC number 1710/2025. Full stop. However, the said position is disputed by Mr. Ayat Shaikia, learned counsel for the petitioners. We can put it together.
together.
Or
37 to 44.
37 to 44 accept kar dena. For the petitioners. Full stop. In view of the above position, Ms. Burman shall file. Ms. Burman is directed to file the affidavits on behalf of the district commissioner, Borpeta. Borpeta all?
Yes.
Borpeta in each of the writ petitions involved. Full stop. Let the said affidavits be filed within a period of 6 weeks from today. Full stop. Registry to list these matters again after 6 weeks on a date to be fixed by it.
In terms of the district commissioner will be directed to, my lord, communicate that deficiencies.
We'll not do that. We'll now have the affidavit. That is what we wanted to do. You don't want to come back, let them bring it on record. We'll see what can be done.
Okay. In the order, my lord, that, my lord, in the affidavit, they can bring on.
Let them file the affidavit. Who am I to instruct them? That is for Ms. Burman to instruct. She will do it. Why are you jumping the gun? She'll do it. But that was a good order for you. Anyway, no problem. Yes.
My lord, only one bearing, my lord, simple lordship is condone the, my lord, just put one line, my lord, to suppose pendency of this rate petition, the period may kindly, my lord, consider.
That, why should I put? That is automatic.
No, lordship, I'm praying, my lord, just see for a moment, a line, my lord. Yeah, instead of justice, nothing, my lord, my lord. It is just a prayer, my lord.
Ends of justice is not one direction. It should be unidirectional.
Absolutely, my lord. Kindly see, last line, my lord. If the appeal shall be. It will work out or I don't know, but
I'm sorry.
my lord. The lordship may fix it matter for my lord. I would like to argue this matter. My lord.
Okay. Let him argue.
My lord,
Is there an interim order here?
yes, there is a entry order.
Then that Mr.
Lordship, may I-
Saiwala is suffering.
Any date, my lord.
Today?
My lord, the 2-3 judgment I have found, my lord, but only one preparation required, my lord, because only yesterday night I have got, my lord. Because my 2 issues are.
We'll have it on Tuesday.
Tuesday, my lord, no problem.
Mr. S. Chamaria, Learned Counsel for the petitioner submits that he be granted 2 days time to place on records decisions applicable in support of his submissions in the matter. Full stop. Mr. J. N. Saiwala, Learned Senior Counsel appearing for the respondents number 5, 6, and 7 expresses urgency in the matter. Accordingly, registry to list this matter again on 3/6/2025. No further adjournment in the matter would
My
be
lord,
granted.
lordship, intimate, my lord.
Interim prayer to continue till the next date of this.
Well, not next Monday, my lord.
Tuesday,
Uh,
3/6.
3/6 is, my lord, not next.
You want it on 10/6.
No, not my lord. Today is 23rd, my lord.
Oh, sorry. Today is 23. We'll have it on 27. Sorry. 27/5. Sorry. 27/5. In the office note dated 23/9/2024. AD card, a service report upon respondents number 2, 3, and 4 is not complete. Full stop. It is seen that the notices were office note dated 25/2025. 2/05/2025. It is seen that the notices in the matter were issued on 31/7/2024. Full stop. Accordingly, petitioner is directed to take fresh steps for service of notice upon the respondents number 2, 3, and 4. Full stop. Steps be taken within 3 working days from today. Full stop. On receipt of the requisites, on submission of requisites by the petitioner, registry to issue notice upon the respondent number 2, 3, and 4 by way of registered post with AD. Registry to list those matters again after 4 weeks.
Chairman, Lord, I am appealing for response number 4, my lord. We have received.
Yes.
On the last student, respondent was about to file affidavit, my lord.
Why affidavit is required? There is a order passed on 9/12, right? 9/12/2024, in pursuance to the directions passed by this court. What is the direction? It says, consider the representation of the petitioner as per stipulation of so and so on its merits in accordance with law within a period of 2 months. Now they have passed this order. Rightly, wrongly, they have passed this order. They have rejected your claim or accepted your whatever it is. This will hold the field. And this court had not directed in a particular manner. So if you are aggrieved, you come back, make a challenge to this. Say, this is only a view.
That's fine.
You need not accept it. You make your submissions. Why? This should not be accepted.
My senior is done.
You are quite senior.
No, my lord.
You tell me what you have said. This court has said is not correct. This order is wrong. Tell me. Then I'll only add one line or one word. Why? Satisfy me. I'll do the needful.
Possible let my senior come, my lord.
On the prayer of the learned counsel for the petitioner, registry to list this matter after 4 weeks on a date to be fixed by.
If there's any fixing in date, my lord. Any fixing in date, my lord. After 4 weeks.
No, mandamus per se, my lord. Page 20.
No, let him senior come.
Yes.
4 weeks.
Yes.
Okay.
I'm obliged.
Already complied. Page 25.
None appears for the petitioner on call. Full stop. Mr.
AJ Hazari.
AJ Hazarika, learned counsel appearing representing the sole respondent, has submitted that the sole respondent, in terms of the directions passed by this court-wide order dated 7/6/2024 in WPC number 110/2021, has already issued a speaking order dated 23/12/2024, whereby determining the compensation payable to the ex gratia compensation payable to the petitioner at rupees 5 lakhs. Full stop. In view of the order, passing of the order dated 23/12/2024, this court is of the considered view that the directions as passed, while the said order dated 7/6/2024 has been substantially complied with. Full stop. In view of the above, the present contempt petition stands closed. Notices are discharged. However, the petitioner is at liberty to present a challenge to the order dated 23/12/2024 in accordance with law, if so advised.
I will.
No timing today. Yes. What is your case? Why?
They have raised a question.
Hmm.
Department can comply with this order because there is a, my lord, may kindly peruse my.
Have you filed an affidavit?
My lord,
Where is it?
page number 20 is inquiry report. After inquiry, they have come to know there is no record available in original, my lord. If they.
That is, there is a Xerox copy available.
Yes, certified copy is available.
Certified copy is available.
On the which.
So, is your records accessible to the petitioner? Then it is with you only. Who is responsible for maintenance of that records? Why should the petitioner suffer?
My lord, if they can submit.
Why should they submit? From where will he submit today? Originals he is given to you.
Also, it is an inter-department documents.
Those are documents, your FD, NSC, all these things will be given original to you, not Xerox.
My second instruction, my lord. The security deposit and my lord, NSC and KVP also not available.
That is your headache.
No.
If there is something there, this will not do. I'm sorry.
With the presumption, my lord, they have manufactured this work order because, my lord, this is the first.
Where is your statement to that effect that this order is manufactured?
My lord, this is the first writ petition in 2011. It's a 2001 to.
Madam, where is your statement in your affidavit that this is a forged work order? Nothing is here. Then
If they can submit before this honorable court, then also they.
why
can-
should they? This is contempt, not a writ petition.
My lord, in order also, my lord, standing counsel is submits only, and they have not filed any affidavit, my lord.
Whatever it is there. Today
The
that
amount
it-
was due on the basis of, my lord, the certified copy only. That's a demand proposal was also sent, my lord.
have you filed a reply to this affidavit?
My lord, they-
Huh? File a reply. File a reply. Okay? Item number 48 and 49 are same.
Same.
48, 49. The petitioner submits that you file a reply to the affidavit filed by the respondents. Submits that he be granted a 2 weeks time to file a rejoinder to the affidavit filed by the respondent number 1, 3, and 4.
My
Don't
lord,
know.
1 week, lord.
Oh.
Only 1 week. Within 1 week.
1 week, we have 1 week time. Registry to list these matters again after a week, along with, after a week.
My lord, I am extremely sorry, my lord. My item number was 47, my lord.
Huh?
47, my lord. I was a little late, my lord. I am sorry, my lord.
Huh. They have given you 5 lakhs. They have passed an order.
Proposal was sent, my lord.
No, there is an order, determination by the deputy commissioner that you are entitled to 5 lakhs.
Yes, my lord.
Further compensation, they have sent to the thing. This direction was to the deputy commissioner to determine your compensation. They have determined it. If you are aggrieved, come back, make a challenge to that. That's what only we have
My
said.
lord, determined and the order was passed, my lord, but a proposal was sent today.
Fine, that they will pay.
Within a time frame, my lord.
No, that cannot be. Item number 47.
my lord, 47.
Heard, Mr.
W. Rahman.
W. Rahman. Yeah, I have said that if you have any grievance, come back, make a challenge to that. Okay?
Obliged, my lord.
Also, provisional dated 9/5/25, my lord. Usual process has been completed, my lord, but the instructions are not.
Who is that sole respondent?
My lord, Deputy Commissioner, my lord.
Mr. Paul, you or Mr. Roy can also do that. Government
Sir, I also know.
seen the office note dated 9/5/2025, which reveals that the notices have been served upon the sole respondent. Mr. S. Roy, learned additional senior government advocate, junior government advocate shall receive instructions from the deputy commissioner in the matter and apprise this court on the next date of list with regard to the status of compliance of the directions passed by this court-wide order dated 2/2/2024 in WPC number 6989/2023. Then the name of Mr. S. Roy be reflected in the cause list on the next date of listing. Same.
My lord, in the
51.
item 51, my lord, service complete, my lord.
Lordship, in 51, I have received a. Sanction was given not because of finance. Fine, it's not a problem. Sanction has been.
Full stop. Then now only the financial fixation is required. How much time will you require?
Lordship, it is up to the finance department, Lordship.
Sorry?
Because
FOC financial sanction is granted. FOC is just a consequential step.
Lordship. Was not grant, finance department.
The elephant has come. Now the rope is only left. That will automatically come. So 2 weeks, 3 weeks.
Let it be after 3 weeks. Lordship.
Mr. S. Roy, learned counsel for the learned counsel appearing for the respondent submits that the matter with regard to compliance of the that the compliance of that the processing of the matter with towards compliance of the directions passed wide order dated 4/3/2024 in WPC number 7028/2023 is an advanced stage and accordingly submits that the matter be, that the present petition be taken up after 3 weeks so as to enable him to place on record the compliance report. Full stop. Prayer is not objected to by Mr. R. Sharma, learned counsel for the petitioner. So accordingly, registry to list these matters again after 3 days, 3 weeks on a date to be fixed. You can take this back.
Look.
Petition is filed
Wait, this is not a ground for review.
only because no.
What steps have you taken against him?
Lordship,
Have you taken any steps against him? Against your advocate?
no, my lord.
Then?
contempt case was also filed, my lord, immediately after receiving the notice, my lord, of the contempt case, my lord. So cause reply file and we have challenged this.
No, no, where is that? Where is that error? There is no error.
No, actually there is no error,
Then?
but consent was not given.
That
Only
is
this
how
that
can
consent.
I
The
determine?
learned counsel for the petitioner was not given that consent.
Can't help
Before
it.
your lordship.
Have you
he
taken
submitted-
steps? Yes, Mr. Sharma, in this situation.
In a review, Lordship.
I can't go into that.
Record it should be.
I can't go into that.
Only notice may go, my
No,
lord.
no, no. You satisfy me on that. That this is a case for review.
Because wrong consent.
That how can I
Yes.
know? How can you're saying will not do now? The same set of counsels had come up and said that, sorry, this was a misunderstanding. It would have been a different issue altogether. Now you are not there. How can a different set of counsel file a review petition?
Then I contact with him, my lord. Yeah, sometime we give, maybe.
On the prayer of Mr. H. Das, learned counsel for the petitioner, raised for an adjournment on the matter, raised it to list this matters again after 6 weeks on a date 2 weeks by. Yes, madam, what is this? You're not interested. You are going beyond the orders of this court.
No, your lordship.
Yes, you have filed that petition to show.
No, your
We
lordship.
closed the writ petition. Now you have put it defective and till now it is defective.
No, your lordship, it's not defective.
Then that is the
Lordship,
stand.
2 dates, I would like to say this.
Notices have been issued.
Yes, your lordship, it's fixed for, it's on 31 for admission hearing, your lordship. On 31/5, your lordship. 2 dates have been gone, your lordship.
Next one is 31/5. Miss
M.K. Sharma, your lordship.
Miss M.K. Sharma, learned counsel for the respondent, appearing in the respondent, submits that the appeal, it's called an appeal. An appeal filed by the petitioner before the jurisdictional education tribunal is fixed on 31/5/2025 for admission hearing. Full stop. When were the notices issued here?
It was on-
You know the date now, 31/5. It's here.
I don't have a copy.
8/4/2025, your lordship.
Have you taken steps?
Yes, your lordship.
Okay, here the respondent number, the applicant number 1, Dipti Prasad Tegu, he has not been made a party.
Who?
In the, this case, which they have
You have an opportunity now. You know it's on 31/5, it's there. Appear, take all necessary steps. So, accordingly, raised it to list this matters again on 13/6/2025. So, on the next date of listing, the learned counsel for the parties shall apprise this court about the further development taking place in the proceedings pending before the jurisdictional educational tribunal. Now we will be keeping it, monitoring it down. Don't worry. You take steps, whatever is to be taken.
obliged.
Your lordship, as per office note with 22/5, lordship, service report await lordship of respondent number 6 and 7.
Your lordship, I am appearing on behalf of the respondent number 8, your lordship, and I have filed the affidavit, your lordship, today.
But unserved notice on 6 and 7 have come back. Insufficient address. Why?
Kindly allow me, I will ensure the address and I will take face lodging
Your name?
at Alugda.
Ms. A. Talukda, Learned Counsel for the petitioner submits that she be granted 3 days time, a week's time, 7 days time to take fresh steps upon the respondents number 6 and 7 at their correct address. Full stop. Prayer accepted. Petitioner to take fresh steps upon fresh steps for issuance of notice upon respondent number 6 and 7 by way of registered post with AD at the correct address of the said respondents. Full stop. Steps within 7 days from today. Full stop. On filing of such requisites by the petitioner, registry to issue notices upon respondent number 6 and 7 by way of registered post with AD. Okay. Matter be listed again after 4 weeks on a date to be fixed by the registry.
Your Lordship, we have filed affidavit in opposite service. No plans.
Asani, you?
Item number was 45. I was late.
Item number?
45.
Yes, no?
So,
Hearing, sir.
contempt petition. I may be allowed to take fresh step.
4 weeks, steps, fresh steps, I have directed for fresh steps.
Fresh step, justice are really possible.
No, contempt, no justice.
Fresh step.
Fresh steps.
Okay.
Lordship, I got the point what my lord is asking. That period, during that period is invalid. So Lordship, that period, exemption of that period.
Then?
Lordship, may grant.
Yes.
No, this is, our prayer is that our vehicles should be kept in S form.
But today, that period is gone.
From the date of applying. From the date of applying.
Can it be done retrospectively?
It is, application is with them.
Only for that period. For whose
Then
period
after that, what will happen?
they have,
after that-
she will have to pay.
After that, we can again revisit it. After 9 months, we can revisit it.
But when is that period? That 9 months is over now. You had submitted this application form when?
That can be that can be done that. Our
22,
vehicle may be
12,
kept under
20.
S form
2020.
20.
So 9 months is gone.
9 months. So 9
So
months,
you have come up before this court after that, 23 only.
my lord. They were not replying us. They were not giving any reply to us. That is why they have.
Oh,
already-
they have not given you that form also. So
that
you
they-
knew about it.
They have not replying, they're not responding to me. I have to go for RTI about fate of my application. Then our first appeal, then second appeal, again second appeal review. Thereafter, the action was given to them to give me reply to me. What is the
But
reason?
how can we now,
Thank you.
Mr. Gaur, give you from 2020?
That is vehicle is still lying and that application is still lying with them. So for that
No,
period.
for that, now you will have to have a fitness certificate, up-to-date fitness certificate.
Then that period fitness certificate was there. So
Forget
that
it.
period, after
Now
that period-
today you will have to have a fresh fitness certificate of
Yes,
the vehicle.
after that, we shall.
I
follow
give
the
you,
process.
I'm giving you this.
After that,
Okay, I'm giving you.
therefore,
From 22/12/2020 for 9 months, I have granted. After that, what?
after that, we shall follow the process. That is
When?
the
You
particular-
can't, that is already gone.
No, that process will be followed after that. For validating process, that will be followed. after
I'll,
that.
I'll say I'm giving it to you till 31/36/2021. I'm granted. But from 21 to 25, how can I direct them to grant you? Because that time the relaxation was not there.
Yeah, that time let's say, for that period,
How to get over with this? That you have denied him illegally. You could not have.
As per our paragraph 6, my lord, Bahan Portal did not accept. Bahan is.
I got it. Yes, what is your affidavit?
The state government stand.
Why his application was not how to get over his problem? Because he's not at fault. You have extended the validity. Have you got a copy of the affidavit file?
I have got.
What is that?
Actually, their affidavit is that it is not their responsibility, is responsibility, now it is responsibility of the state government. They said yes. We have
Yes,
issued-
madam. How do you get over this?
Lordship, for that period, Lordship may direct.
No, that will not help.
After the notification is not extended beyond that,
I know that.
only that
But-
COVID period. But
But if I put him in FH and for that period,
For-
what will happen thereafter? You
then
find out a,
she will have to for update her.
he can't go and have a check of his vehicle as of 21 now, 22 now. That will be only for the present. In the meantime, middle part, what will happen? He will have to pay.
Yes, he will have to pay.
You will have to pay. For that 9 months, 11 months, whatever is that, we will exempt you.
Yes,
But after that, you will have to pay.
he will have to pay.
That can, let me put in this way, that we have been declared illegally. So the F form may be granted, S form may be granted.
H
according to-
form will be
and
granted.
Thereafter due process will be followed.
Due process cannot be followed because neither there is an exception nor there is a anything after that extending that thing. So moment the period from 22/12/2020, the period ends, or even after 36/2021, you are at their mercy. You will have to pay. You will have to pay.
It is because of their fault.
Their
they
fault.
will
I
have
am
to-
condoning that.
No, that is there. And
That I am
thereafter also-
condoning. After that, what?
Well, thereafter also, whatever benefit I would have got, I have.
Your
I
this
have been
vehicle
deprived
is
because
not,
of them.
this vehicle is not being operated now.
No problem. All original documents are there with them. I cannot operate it. All original documents are with them. While submitting as form.
Madam,
submit all
you
the documents
apprise
there.
this court. Have your instructions how to get over this situation.
Yes, Lordship. Lordship, rule 49(2) regarding the age form. I don't think I have it. It's more temporary exemption of taxes, madam. Lordship, kindly have. That period, Lordship, I have no objection. I have. already-
No. That part is okay. But after that, what? So that is it. For that period, we can condone him.
Yes.
But after that, what?
After he will have to pay.
Because after that, he'll have to take all those documents
Yes.
from 21 till 2025. He does not have it. From 25, he will have to again apply.
And they will again impose penalty upon us also.
They can.
That is, they will. again-
Because you have come up only in 23, mister.
No, no, I have come on 23 because they never replied to me anything. RTI has been done, your lordship, the record is there. RTI has been done. At last, they have replied us on
K.
26
Leonard
June.
CG submits that an affidavit on behalf of the respondents represented by her has already been filed. However, the same is not tagged with the records of the case. Full stop. Ms. M.D. Bora, Leonard Standing Counsel, Transport Department, shall receive instructions as to the manner in which the petitioner can be granted H form after the period for which an application was submitted by him on 22/12/2020 had expired. Full stop. Raised to list these matters again after 3 weeks, along with the affidavit filed by the respondent number 4 in the matter. Full stop. Ms. Bora shall apprise this court on the query raised herein above on the next date of listing.
Date may come with the-
Lordship, may kindly give it the part, madam.
3 weeks, Krishna. 1, 2, 3. 18 ko idea. 3 weeks on 18/6/2025. So good?
Obliged, Lordship.
Hmm.